go. And ready. Okay, all right. And time, I need my phone. Okay. Microphone. Okay. Okay. Hello. Okay, that's working. All right. I think everything's working. Okay. So, Monday. Okay, so I got everything marked on the weekend. It took me a really long time. I was super unconcentrated, but that's okay. Turn out a little bit more light here. Midterm 2 looked pretty good. I mean, the class average on the midterm dropped, but it only dropped about 0.5% over the first one. So it was pretty close to equivalent. Like I didn't see a big difference. So I was pretty happy. I mean, just kind of looking through the results, I didn't do like a deep dive. Some people went up, some people went down. If you want, if you want to see your exam, do feel free to stop by my office. I'm in the office all day tomorrow. And yeah, I'm in the office all day tomorrow. So pretty much 9:30 till 3:30. If you want to take a look at your exam, feel free to stop by. We can have a look over it together, and everything will be good. Okay. Any questions before I start in? We're going to start with crime today. We're going to do what we can. Yeah. Anyone? No? No one in the online coterie? I'm going to check my YouTube to make sure everything's working. 5 people watching. Oh, please stop with the sound. We're going to start. There we go. All right. Well, if there's nothing, then I guess we will jump in. Kind of want to make sure, because I haven't updated this one, so I'm going to make sure that still works. Okay. All right, so today I'm just checking that this works. Yay, it works. All right, perfect. Okay, so we're going to start talking about crime a little bit. I've shortened this unit down a little. Oh, sorry, Shelby. So it would have been 82.5, I think, and yeah, so this one is just like flat, about 82. So yeah, no worries. I'm just staring at this screen. You can't see it, but it says no bootable drives have been found or no OS on the terminal for the classroom, which is going to be a problem for the next person if they need to use it. Okay. It's been a while since I taught youth crime and society, but all this material kind of comes out of that class. All right, so we talk about youth and youth crime, right? Really thinking about youth crime as a separate phenomenon, something that isn't part of, the kind of overall justice system, really goes back kind of to the end of the 18th century. So at the end of the 18th century, what do we have? So that's, the latter part of the 1700s. You start to get people thinking again, and it's part of this long-term evolution that we talked about, starting with Neil Postman, right? That we get more and more thinking about young people as somehow different and as needing their own levels of protection compared to adults, right? That they are somehow different and need something different. So, end of the 19th century, we get the first use of the term juvenile delinquent. Basically, for violations of the law by a person under the age of adulthood. So we start to differentiate juvenile delinquency from regular kind of crime or deviance. By the 19th century, the term is so widespread that we start to see a new juvenile justice system put in place. Now, the way that it actually ends up working is that we have the institutions of the youth justice system start to appear before an actual court system. So kind of middle part of the 19th century, you start to get industrial schools, reformatory schools, and other institutions of the youth criminal justice system starting to appear in society. So only towards right at the end of the 19th century, so the last decade of the 19th century, do you get the formation of a special youth criminal justice system that's there to deal with the needs of delinquent children. Okay. Again, that's not to say, and I think it's important to stress that, some accounts, and especially if you look back at, say, like Philip Aries, who's a very famous kind of European scholar of young people, there was this sense that, there was no difference between how youth and adults were treated in the past. And that's not strictly speaking true, right? So we don't want to exaggerate this. There's always been a sense that young people should be treated a little bit differently in the criminal justice system. If we go back, into, I don't have my pen. How can I circle things if I don't have my pen? Where is it? If we go back into English common law, I have no idea where I put it. Oh no. There it is. Going back into the 14th century, right? 14th century, so 1300s. We find in English common law this idea of, the Latin term doli in capax, which basically is the idea that young people are somehow different in their legal culpability, right? Doli in capax basically means incapable of doing harm in Latin. And in English common law, and like I said, going back into the 14th century, we see this in English common law. There's a presumption that children under a certain age are essentially incapable of understanding what they're doing well enough to actually commit a crime. So in the kind of legal statutes, right, and again, it develops from the 13th century forward. By the 19th century, this idea of doli in capax is very well formed. And you get this notion that between the ages of 7 and 14, right, basically, you can't be prosecuted for committing a criminal offense unless the presumption that the young person can't commit a crime is contested by the crown, right? So by the state. So the state could say, we think this person is capable of understanding their crimes, and you could attempt to prosecute them, but it would have been something the crown had to actually seek. Children under 7, right, not able to be convicted of criminal offenses at all under British or English common law. And basically between 7 and 14, you had to take those case by case, and the crown had to challenge certain assumptions. Okay. So all of these are basically predicated on, did I switch back to my pen? I did, okay. Predicated on the notion of what's called diminished criminal responsibility. And that young people have diminished criminal responsibility. That basically individuals who are not adults can't be held fully responsible for criminal behavior. Now, that said, there are different age-graded levels of diminished criminal responsibility. And some of these will also apply to, say, mental status. If a young person, is seen as not cognitively developed enough, if it's, they have a mental disability, all of these sorts of things can play into this as well. But the three basic levels of age-graded criminal accountability, no criminal accountability, right? So below the age of 7, basically you can't, and to this day, right, you would not be able to charge someone who's that young with an actual crime. You could refer them to social workers who would deal with them in a different way, but you can't send them to court to be tried for a crime, right? Because the presumption is they can't understand their actions well enough to actually know that they are committing a crime and think through what the possible consequences of committing a crime is. So basically now, between like 7 and essentially, well, I guess in Canadian law, it's now 12 and basically 18 years of age, we tend to think of limited criminal accountability. So basically, kind of between 12, and this is under the Youth Criminal Justice Act, which I'll talk about at some point. Youth Criminal Justice Act, the current youth crime legislation in Canada. Basically, anyone under 12, we say no criminal accountability. Anything above that, we're talking limited criminal accountability. So we realize that at 12, you should have a basic sense that what you're doing is criminal, but that you probably don't have, long-term thinking, the ability to understand that what you are doing is fully criminal, right? So we say, okay, with some accountability, we can put people, either into some kind of social programs, or depending on the severity of the crime, we can put them into youth prisons, but we don't hold them accountable in the same way. And this typically is expressed in the sentencing, right, where there's limits to sentencing for young people, even for crimes like murder, right? Even if you get, first-degree murder, you're not going to get the maximum adult sentence, right, which is 25 to life. The youth sentence is somewhere between 5 and 7 years at maximum, right? So, because even if you kill someone as a young person, the assumption is that you have less responsibility. You don't understand what you did as well. Reg, when you did that, when you touched your head, I thought you had a question. I was like, oh, a question. No, it's okay. All right, and then full criminal accountability, right? This is what we think of for adults, right? Once you cross that, if you hit your 18th birthday and you commit a crime, suddenly you are fully culpable for everything you've done, and you is going to jail. All right. Okay. So the whole kind of youth criminal justice system is fundamentally predicated on, in Canada, on this concept, which is called parens patriae. Again, Latin term. Technically speaking, what does it mean? It means, father of the country, right? So if you look down here, it means father of the country. That Latin translation actually tells us diddly squat. And many a time in Youth Crime and Society, I caught people on a multiple choice question that asked them what the term actually meant and screwed them over because they translated the Latin literally and they thought it meant something different. But basically, parens patriae, in our sense, when we talk about youth criminal justice and youth welfare, is more like the... Do you actually have a question now, Rich? Okay, go for it.
Why is it sometimes in the States, when people are around the age of 16, they can be charged with more than 5 to 7 years of first degree murder?
Yes, that's an interesting question. The U.S. has a different conception of diminished criminal responsibility. So there's a couple of things that happen in the U.S. legal system. One is they have a different sense of when you become kind of fully responsible for your actions. And there's more ability in the American system to basically reconsider someone as an adult, right? And a lot of times, part of it is the overwhelm of the criminal justice system in the US. There's so much crime that they actually just push young people up into adult court. But they have different rules as to who can be tried as an adult in the US. And the prosecutors can argue based on the severity of crimes for some people to be tried as adults. In Canada, you actually can't. There's essentially no circumstances under the current legislation, the Youth Criminal Justice Act, in which you could move someone up and have them tried as an adult. It's basically impossible. I think legally there's like a few like technical ways that you could do it, but it's so difficult that it almost never happens in Canada, like 0.1% of the time or less. And so it's just a different way of kind of thinking about it, and especially thinking like, okay, how does the severity of the crime equal to how they should be sentenced, right? And criminal responsibility. The American system has a slightly different understanding of that. Whereas like, oh yeah, at 16, if the crime is severe enough, then we can try them as an adult. The US also has more of a kind of focus on retributive justice, where it's like, you have to pay your debt to society. And so it's like, oh, this person committed a terrible crime against society. Now they have to pay for it in prison. It's not a philosophy that I think makes any sense, but sorry, does that answer your question?
Yeah,
okay. Did I over answer your question? It's a complicated. And the American and Canadian systems, well, they are related. They are, I don't know, could we call the American system the British's misbegotten stepchild, right? The slight product of inbreeding at the highest levels. I don't know. The American justice system is fabulous and complex in its own ways. Otherwise, all those legal dramas on TV wouldn't be so much fun to watch. All that stuff. Okay, what was I saying before? Reg asked this question. Oh, parens patriae, right? Okay, the idea is that essentially the state takes on the role of the parent, right? In the case where a child's parents are either absent or incapable of caring for them properly, basically the country becomes your father, which would be, I think, the more, technically parens patriae translates as father of the country. More properly in kind of legal terms, it's like Canada's your daddy. That would be, I think, more correct in terms of a legal interpretation. So basically, this is the kind of foundation of the Canadian and kind of British common law understanding of how we deal with young people. That in the case where they are not being cared for by their parents, or their parents have proven incapable of caring for them, which is why they went and committed crimes, the state takes on the role of the parent. And this remains kind of deeply entrenched in Canadian law and British common law in general. Okay, so the belief that misguided children need to be treated with friendly helpfulness. So this comes from the original kind of youth justice legislation in Canada, which comes out of what's called the child saving movement, which I think I talk about it on the next slide after this. But the idea was that the state was there to help, right? Is that the state was there to help these young people to be, friendly to them and essentially to guide them towards a more helpful and tolerant and adjusted adulthood. So in the early kind of legislations, and specifically if we look at it, we'll talk about the JDA, the Juvenile Delinquents Act of, I think, 1918. Judges were given broad discretionary power to basically be the parent, right? To be the young person's parent and deal with them as they saw fit. Typically, they were put on probation, and judges were given essentially unlimited power over the young person until their 18th birthday. Okay. So, all right, the JDA. The JDA. Oh, it's actually earlier than, I was going to say 1918, but I'm wrong. 1908. So the JDA, this is actually Canada's first piece of juvenile crime legislation. So I think what's notable, if we look at it here, it is the longest lasting youth crime legislation in Canadian history, so far anyway. Lasting, from 1908 until it was replaced by the Young Offenders Act in 1984. So it's really, really long lasting, and it was amended a whole bunch of times over that period, but the basic kind of framework remained through that period. Okay, so what's notable about the Juvenile Delinquents Act, aside from the fact that it was the first youth justice legislation in Canada? Okay, so amongst other things, the provinces had great jurisdiction, as they tend to generally in Canadian law, in terms of setting things like their own maximum ages for it. So it ranged anywhere from 15 years old to 17 years old, after which point you would have been considered an adult offender, right? So prior to 1984, when it's replaced by the Young Offenders Act, basically the provinces set their own kind of boundary, and either you were an adult when you turned 16 or when you turned 18. And it could be different for males and females. Males tended to be found, criminally responsible earlier, and females a little bit later, right? Females was more towards the 18 years old. Okay, it was, the enactment happened in 1908, and it was the culmination of a long process that had basically started in the 1880s. So, if we want to go, let me go back. We'll go back in time, right? In the prior to the 1880s, really from the kind of middle part of the 19th century forward, you had what I would describe probably as a bunch of would-be do-gooders that had founded what they called the child-saving movement. And it goes along with a lot of other things that are happening sort of in Victorian England and Victorian Canadian society, where where basically people have slow down, think. Sorry. We're seeing the effects of industrialization and the creation of these massive industrial cities on society as a whole, right? And you have a lot of social dislocation. People have moved from the countryside to the cities. You have these massive industrial cities that have sprung up. The conditions are very bleak for a lot of people, right? Both parents in a lot of cases are working, usually dad in the factory, mom at home doing some kind of work while she also cooks, cleans, and cares for children. And they're living in slums. Children often are unsupervised. Their parents are both working, so they're sent out to play in the streets of particular cities in England and in Canada and in the United States. And they get into lots of trouble. There's also obviously a lot of orphaned young people, right? A lot of young people that get abandoned by their parents who, essentially can't care for them because, they can't make high enough wages to care for all the children they have. So they get abandoned. So you have a lot of children who are in pretty dire circumstances, or they're getting into trouble, and they start committing crimes. This is the period of, say, like when Dickens is writing Oliver Twist, right? And there's all sorts, you have characters like the Artful Dodger who get into all sorts of trouble and are basically, forming sort of youth gangs to support themselves. And what you get as a cultural kind of response from the, waspish elites, or the white Anglo-Saxon Protestant elites, right? Those fine English people who are in the kind of upper echelon of society, folks like this cat, J.J. Kelso, who's a journalist in Toronto, is that you get what's called the child-saving movement. And it sort of develops in Canada, the US, and in the UK around the same time. And it has this attitude of, it's the culmination of this idea from the elites that, we have children, and poor people's children, they're also children. Look at their circumstances. Their circumstances are fairly dire. We really need to do something to help them, right? Now, there is a lot of cultural and economic chauvinism built into this as well. When we come to the United States and Canada, and you have the Irish and Italian immigrants, right, who are initially quite poor, who have lots of children, there's a kind of anti-Catholic bias built into the child-saving movement as well. But overall, the people who are part of the child-saving movement see the dire circumstances that the children of the poor and working class are in, and set about, essentially trying to use the state to better their circumstances. So what do we get? We get folks like J.J. Kelso, again, who's a journalist in Toronto, lobbying for an act for the protection and reformation of neglected children, and an act for the prevention of cruelty to and better protection of children. So what we get out of this is two things, right? You get protection and reformation of neglected children, right? So the state is going to step in and take care of children whose parents can't care for them in an institutional fashion. And then, the prevention of cruelty and better protection of children. So what we have from this is the foundations of both the youth criminal justice system and the youth social welfare system, right? Social services, as we think of them today, ultimately has its origins in this movement, right? So, when you call a social worker because a kid is getting neglected, in some sense, you can thank J.J. Kelso and his peers for the fact that these systems exist. Because seeing what was happening to children in these industrial cities, they thought we have to do something. And again, we can think of Postman here, because this is a culmination of, wow, we have children. Oh, those are children too. We really should not let them live like that. And that's the system that ends up being created. Now, in some cases, it's a very cruel system. I'm trying to remember what I have on the next slide. Okay, I'll talk about it in a sec. But in some ways, it's a very cruel system because young people are often, held in that system for a very long time. They're sometimes sent to industrial schools, right, which are essentially boarding schools, where they're forced to work so that they can learn factory skills. So eventually, they can be productive workers. Judges have almost unlimited authority over them. There's things like in this system, young people were not legally entitled to a lawyer, and they were sometimes discouraged from having a lawyer present during trials. So can you imagine it being just you and the judge? And the judge is like, well, you're going off to a boarding school where you're going to make t-shirts. You'll get out when you're 18. Have fun with that. Okay. But the intentions were good, as many things were. Kelso, is an interesting figure. He wants to take credit for creating the JDA, right? And once it's passed, he long lauds himself as the advocate of children who created the JDA. The actual person who wrote the legislation and brought it through Parliament is this guy, W.L. Scott. Two names that I always get completely confused because, two letters and a first name makes it almost, or I guess Kelso is not a first name, but I always think Kelsey. So J.J. Kelso and W.L. Scott, they always sound the same to me. But basically, Scott is recognized as the actual person who wrote it. And he was an Ontario parliamentarian. Okay, so the initial kind of origins of the JDA are strongly influenced by the Americans. Obviously, because they got there a little bit earlier. The first youth court in the U.S. is founded in 1898, so just a few years prior to Scott and Kelso kind of trying to think through this legislation. The U.S. has a child-saving movement as well, so they get stuff from Victorian England too, and they're having the same problems with big industrial cities and lots of immigrants and lots of poor kids and all that jazz. So you do have the same thing in the U.S. Okay, so what happens is Scott, W.L. Scott, goes over to the U.S. and specifically, he goes first to Chicago. Chicago, right, again, basically across the lake from Toronto. And there he sees the first model of a youth criminal justice court, right, where the first courts were founded in Chicago in Cook County. So he goes over there and he looks at, okay, what does this look like in terms of the court system? And then he goes to a conference in Philadelphia where he talks to justice reform experts, Judge Harvey B. Hurd and Judge Ben Lindsay, who have created a probation model where basically rather than sending young people to prison, they are basically assigned probation where the state will direct their actions and tell them they have to meet certain conditions to remain free. And this is where you get people sent to industrial schools and reform schools and all of these other things. Okay. You also have some other influences from far afield, because this is kind of going on all over the world. So you have some German influence, some French influence, a lot of British influence, and even some ideas coming from as far away as Australia. And so it's sometimes, thought of as one of the first really international cross-fertilizations of ideas about justice reform, because everybody's looking at the experiments that are being run in other places, because this is a new problem that's come up. And basically it's like, okay, what are we going to do? And so they adopt all sorts of formulas from all sorts of places to form, the kind of initial form of the justice system. Okay, so it's really, really, really broad, right? There's a pretty wide net in defining delinquency and dependent children under the JDA, and a lot of discretion is given to the Crown and to judges, right? So there's a lot of power invested in the legal system. One of the simple things that are, generally considered offenses, and we still have this category of legal offenses in Canadian law today, is what are called status offenses. And these are things that basically a young person can be found guilty of simply because they're underage. So drinking, right? If you're drinking and you're underage, obviously that's illegal. Truancy, right? If you're not attending school, that's illegal. Initially, certain kinds of, if you have sex at a certain age, that could be considered a status offense because you were underage. So there's all sorts of things. And we still have this, right? If you're under 18 and you go and you buy or somehow obtain and consume alcohol, technically you are in violation of the law. That is called a status offense. It's an offense not because consuming alcohol is illegal, because consuming alcohol underage is illegal. So we still have that. Okay, and then indeterminate sentences. This is one of the big problems with the JDA, and again, it will last until the 1980s, is that basically there's no fixed expiration date under parens patriae. So it's not like, the judges were basically allowed to set the expiration date. It could be no later than when the person turned 18. But today, right, and this gets reformed under the Young Offenders Act, it's like, okay, you've been sentenced to 1 year of probation, right? Under the JDA, it was, you have been sentenced to probation. How long will that be? Until the judge doesn't think you need it anymore, which obviously created a lot of problems. Why? Well, because it allowed judges to keep young people essentially under their thumb for years at a time, right? So a young person could be sent to, a reform institution, essentially if from the time they were like 7 all the way until they were 18, if the judge thought that was warranted, right? And you'd have to come back before the judge. And again, one of the weird things, you never had a lawyer. For most people, oops, I can't write on there because it's colorful. No lawyers. No lawyers. Unless you were rich, right? Rich, you could bring in a lawyer, but it was strongly discouraged. And why? Well, it went back to this idea of friendly helpfulness, right? The state was there to be your friend, your dad, your mom. They were there to help you. Why do you need a lawyer with your mom, right? Or your dad? But in principle, it left young people to represent themselves before the court, which obviously put them in a very vulnerable situation. Now, the rich, obviously, if their kids got in trouble, they brought in their lawyers, but it wasn't required, and it wasn't required that the state to give you legal representation. So that was a problem. And the JDA had jurisdiction from 7 to 15 or maybe 17, depending on the jurisdiction. It was a wide-ranging sort of thing. Okay, so how am I doing for time? Usually I look at the clock on the big screen, but all I see is that no OS is installed. Okay. Oh, he just died. It's Brian Mulroney, former Canadian. This is a political cartoon of former Canadian Prime Minister Brian Mulroney. And I'm like, oh, I think they just did his funeral yesterday. Okay, so through the 1980s, one of the things that starts to get discussed is that the JDA, right, which was passed in Shelby. Oh, I'm trying to remember. I know Alberta had relatively long timelines. Ontario did as well. And then initially, I think Quebec also had fairly strong legislation. It's like New Brunswick, Nova Scotia, and PEI had the shortest limits. And I'm forgetting on Manitoba and Saskatchewan and BC. BC, it was probably murder someone, who cares? No, that's just today's BC. But yeah, I believe it was, Alberta, Ontario, and Quebec initially had the harshest ones. Quebec undergoes a transformation in the 1960s and 70s, after which point Quebec's legal system is a magical world with fairies and dumplings. I don't know. But prior to that, they were pretty harsh and really run by that same English waspy elite. But yeah, if I recall. Okay, what happens in the 1980s? Beginning in the 1980s, people start to talk about the fact that the initial conditions that led to, the JDA no longer existed. Right? By the difference between Canada in 1908 and Canada in the 1980s is enormous. Right? Canada in 1908 is a country that had just recently become a nation. It had undergone a really, 1867, it becomes a country. Some of the key legislation for Canada doesn't get passed until the 1870s, right? 1876 is a big year for a lot of key Canadian legislation. But in 1908, it's still a country that's undergone really rapid industrialization, really rapid immigration from Europe, and it's a country that really is still coalescing, and it's a lot of chaos, right? As all rapidly industrializing societies ultimately are, right? Because you're moving people out of rural life into urban life in a really concerted way. So, what do you get? By the 1980s, though, Canada is one of the most developed countries on the planet, right? With a highly advanced industrial and increasingly post-industrial economy, and the conditions that led to the creation of the JDA simply no longer exist. So, people start to talk about the fact that we need to reform this legislation because, basically, it's been amended a bunch of times. The bones of the legislation are from the beginning part of the 20th century, the end part of the 19th century, and conditions that no longer exist. So, the Mulroney government, which, is a pretty courageous government in lots of ways. It's a government that creates a whole bunch of new legislation, undergoes 2 rounds of constitutional kind of negotiations, trying to bring Quebec fully into Canada. But basically, for our purposes, they introduce a replacement for the JDA, referred to as the Young Offenders Act. And it is, from the very beginning, an incredibly controversial piece of legislation. The Liberals, who are back on their heels because Mulroney has won one of the biggest majorities in Canadian history, lambasted the legislation for overprotecting criminals. And basically, it kind of goes sideways. And it sort of gets it from both sides. Okay, so yeah, it's a long overdue reform, and it introduces a bunch of important things for young people. So it adds definite sentence. Okay, so it adds a whole bunch of due process things, right? So it makes it a requirement. Can you believe it wasn't until 1984 that it was a requirement for the state to provide young people with a lawyer, right? But it wasn't. So it adds due process, all sorts of due process clauses for young offenders, right? So basically, you need to have a lawyer present, right? You have to go through the due process of law, right? You have to prove your case. You have a right to a trial by judge or by jury. All of those things that are part of, rapid trial provisions, all definite sentences, right? All of those things get added by the Young Offenders Act. But it sort of gets it both from left and right wings in Canada. It's widely, considered problematic, particularly because it undoes some of the child welfare parts of the JDA, right? And it reconceptualizes youth crime as crime. And so it's accused of, being more based on crime control and child blaming approaches. Now, this is not unfair. One of the things that's true is that crime in the 1980s is essentially at more or less an all-time high, right? We come through this period from essentially 1960 until, essentially ending at kind of at the end part of the 1980s. You see a kind of rapid rise in crime overall before it kind of drops after about 1988, 1989. But by the time the Young Offenders Act is passed, we have rampant crime in Canada, in the US as well. I won't get into the reasons for it, but some of the legislation shifts to, okay, we have to control some of this crime, and it focuses more on, what some critics call a child blaming approach, right? One that basically targets the morality of children as the problem rather than, say, their parents or their circumstances. So it's lambasted from the left, basically for being too harsh on crime, for criminalizing young people, and for breaking apart bits of the welfare state, all of which I think is fair. Okay, it's also lambasted from the right. And specifically on the right, some of the things that they suggest, and you see it in this political cartoon, right? This political cartoon is a good example, right? Obviously, this juvenile person has murdered this old lady, and Brian Mulroney is standing there with his Young Offenders Act saying "naughty, naughty." So short sentences are given. Typically, wide legal protections are given to young offenders, including two that are particularly hated, and they're still around actually. So one is a publication ban on their names, right? Basically, young people, no matter what the offense is, cannot be named in any kind of media reporting of the case, right? So basically, they can report on the generalities of the case, but they can never name the person. So the fear is generally from the public that, oh my gosh, we're going to get these young people who've committed murders and rapes and all of these things released back to communities after their relatively short sentences. And we're not going to know who they are, right? So that's one, like the publication bans, and then the relatively short sentences, and typically between 1 and 7 years. But 7 years is reserved only for one category of crimes, which is violent crimes. So assaults, sexual assaults, and first-degree murder. Everything below that, the sentences tend to be 1 to 2 years, which is seen as, soft on crime. So the legislation is broadly hated. And it's, I guess its critics on different parts of the political spectrum see it as both too harsh and too soft, which is sort of a weird, it probably suggests it was a decent piece of legislation and a good attempt to reform the youth criminal justice system. But ultimately, it ends up being Canada's shortest piece of youth criminal justice legislation because it's so widely hated. Okay, so 8 minutes, I got time. Towards the end of the 1990s. So what happens, right, in 1993, or 1992, I think. The Conservatives, under then leader Kim Campbell, suffer what is possibly one of the greatest electoral defeats in modern Canadian history. They go from over 200 seats to 2 seats, and their coalition is split apart between the Bloc Québécois and the Reform Party in the West. So it falls on the Liberals then to reform the youth criminal justice system. And one of the promises of then Prime Minister Jean Chrétien is to reform the hated Young Offenders Act and create something new. So starting in the late 1990s, around 1998, they start working on a replacement for the Young Offenders Act. And this becomes eventually the Youth Criminal Justice Act, which goes before Parliament in 2002 and is fully introduced in 2003. So, kind of big aspect of the Young Offenders Act is, criminologists and government policy analysts, we're still sort of trying to figure out I think we have a good sense now. We're about 2 decades on from the passage of the Youth Criminal Justice Act. We're still assessing its overall impact. But mostly I think, again, it falls into the too hard on, a lot of criminologists think it's been too harsh on crime. But there's some notable kind of features of it. Criminologists are never happy, by the way. I work with a bunch of them, and they're always critical of everything. I love them, but it's like nothing's perfect. We need safe supply. No, that's too much safe supply. Okay. Okay. Yeah, and I mean, what's kind of noted, it's a part of that broad international shift. Like we see similar reforms in England, in the United States as well, away from a child welfare model towards a juvenile justice or more punitive kind of crime control model again. But I think what's most notable about the Youth Criminal Justice Act is what's called the bifurcation of the youth justice system. And what it creates is it basically has the philosophy that what we need to do is keep young people out of prison as much as possible, right? That the idea, and again, this comes out of a lot of research that suggests that if a young person goes to prison, their odds, for a first offense, especially a non-serious offense, what you get is an escalation of criminality. And the more times they go to prison and the more times they end up in prison, it looks like a mushroom. Okay. I was supposed to be an arrow. I failed. The more times they go to prison, the more likely, and the longer they spend in prison, the more likely their criminality is to escalate. So basically, you get sort of two prongs of the youth criminal justice system under the Youth Criminal Justice Act. And the biggest one is diversion, where basically first-time and non-serious offenders are diverted as much as possible out of the youth criminal justice system, right? They get probation, they get parole, they get counseling, they get drug treatment, rather than sending them to prison. Again, with the idea that if you send them to prison, they're likely to end up a career criminal. And then, so diversion is here. And then corrections, right? Or prison. But corrections is supposed to, under the Youth Criminal Justice Act, be limited to those people that are seen by the system as either really dangerous or they're violent, or for whom all other kind of attempts to reform them through diversion have failed. So ultimately, the system is designed to keep as many young people out of prison as possible. Okay. I mean, all right, do I have time for this? I have time for this, right? 3 minutes, I can do this one other slide. I love Doob. His name makes me laugh every time I hear it. I don't know why. Tony Doob. It just sounds like a drug dealer's name. I don't know why. He's a great guy. University of Toronto. Okay, so yeah, I mean, there's a big debate in Canada and still amongst criminologists and other legal scholars what the Youth Criminal Justice Act actually does. I mean, it's definitely diverted more people out of the youth criminal justice system, right? So it's led to far fewer criminal convictions for young people. However, one of the big problems, so we've had more lenient community-based or diversionary programs. That's become a big part of the Canadian system. However, there's kind of wide disagreement on what else has happened, right? I mean, while the legislation was being written, Hoogeveen, that's Brian Hoogeveen, who's in the department here, and Samditch, were concerned that it was a punitive turn in the justice system. I think that's mostly been proven untrue. Hoogeveen and Samditch, once it was kind of first being implemented, suggested it was dismantling of the child welfare system that had been set up under the JDA and was ultimately beneficial to young people in some cases. But I think, mostly history has proven it to be a pretty good piece of legislation in terms of kind of keeping young people out of the criminal justice system. There were kind of there continue to be fears that it's a system of adulteration, that basically has merged the adult and youth justice systems, where they used to be very distinct. Now they are much less distinct, and it's often the same rooms and the same judges that are I want to say holding court, but that's the wrong term, presiding over the same cases, right? So it's a much less distinct system than it used to be, where you had youth courts that were completely separate from adult courts. Now they're basically merged, and so there's been fears that judges who are used to sentencing adults, then just shifting over to young people, will sentence them in the same ways. But I think on the whole, right, it reduces the level of punitiveness and creates, at least in theory, the goal of reforming young people and giving them the help they need. Although in practice, a lot of times it has been poorly resourced. Resources have often been lacking in the youth criminal justice system, sometimes making it really, really hard for young people to access, say, counseling or drug treatment or the things that the court thinks they need. Okay, I got 1 minute left, but I don't have time for another slide. Oh, dear God, I really don't have time for another slide. We'll pick it up. We should get through, hopefully, the rest of it on Wednesday. It's a short week, right? We only have 2 days. All right, I will discard my doodles We will see you on Wednesday. And then it will be Easter. Okay. What's that? No, Friday is Good Friday. And in memory of Jesus being nailed to a cross, no one comes to school.